Good afternoon, everyone, and welcome to the Australian Earth Laws Alliance, or AILA, Earth Laws Month, where we've been featuring webinars with lots of amazing speakers across really fantastic topics through all of September. I'll talk a bit about that in just a moment, but today we're delighted to have some amazing, lawyers, some amazing women from the Environmental Defenders Office Australia talk with us about the right to a healthy environment. Before I do all that introductions, though, I'd like to just quickly share screen and introduce the topic properly. So yes, thank you very much for joining us today. A really important topic, the human right to a healthy environment and recognising that right in Australia. Today we have Nicole Sommers, Frances Bradshaw and Isobel Brinin from EDO Australia. Really pleased that they could make time to share with us the work they've been doing to look at these issues. Before we commence, I'd love to acknowledge country. I am lucky enough to live, work and play on these beautiful lands of the Kabi Kabi and Jinnaburra traditional custodians. This is a very special pocket within Southeast Queensland. It's become quite a tradition on Zoom now and webinars for folks to share where you are. So please feel free to write in the chat, say hello from where you are, whose country you live on. I'd like to acknowledge that land was never ceded, that the continent of Australia, when settled by the British Empire, there were no treaties. Land always has and always will be part of the Aboriginal peoples of this continent and part of their culture. So I'd like to acknowledge elders past and present and the emerging young people who are coming through and continuing the custodial and cultural obligations of one of the oldest continuous cultures on Earth. As many of you know, AILA, the Australian Earth Laws Alliance, works in partnership with a whole range of very dear Indigenous mates and colleagues, particularly through sister organisation Future Dreaming. So in addition to acknowledging country, we also like to acknowledge the role that we're all trying to actively play in decolonising our hearts and minds so that we can be good earthlings on this continent and really listen to country, listen to place, and do what needs to be done to care for each other and to care for country. So do please pop in the chat where you are. It's always lovely to read the Zoom comments and find out where everybody's joining us from. So the Australian Earth Laws Alliance, if you're not familiar with us, we are small but mighty. We're a think and do tank. We work on helping people understand the kinds of systems change we need to make to shift from human-centred extractivist modes of being and modes of governance to earth-centred governance. And by that we mean, how do we shift things like law, economics, education, ethics, and our entire knowledge system so that we focus on caring for the living world and making sure that humanity is a harmonious part of the world rather than a destructive part. Obviously, that's a big ask. There's a lot of different elements to that kind of work. And Earth Laws Month is really just a wonderful way to showcase many of the people we admire, many of the projects we run ourselves, and really just get everyone thinking about the kinds of systems change and transformation, whether that be law reform or economic change, that we think is very important if we're going to have a livable future. So without further ado, I'm really delighted to hand over to our speakers today. We have three fabulous speakers. We'll start with Nicole Sommers, and then I think she'll be handing over to Frances Bradshaw and then Isobel Brinin. And we'll have about 15 minutes at the end for questions. So I please encourage you to write your questions into the chat and I'll collate them for our session on Q&A. So that is definitely enough from me. Love to hand over to you now, Nicole. Thank you so much. How are you today?
Thank you so much, Michelle. What a beautiful acknowledgement and introduction. I just want to thank AILA for inviting us here today from the Environmental Defenders Office, another wonderful organisation. AILA do amazing work, so thank you so much for having us. And I acknowledge also that I'm on the lands of the Muwinina people today, Nipaluna, Hobart, beautiful country down here, and acknowledge that this land was never ceded. It's really important time to give that acknowledgement, and it's also a really important time to discuss legal frameworks and how important legal frameworks are. And last night in Nipaluna, Hobart, I had the great privilege of hearing from some of our elders and leaders in the country, Professor Megan Davis, Pat Anderson and Rodney Dillon about the Uluru Dialogues and about the voice. I had the privilege of standing in front of the Uluru Statement, the hand-printed statement of 2 ways laws, if I can put it that way, gifted to the Australian people. So I just want to acknowledge that ADO is a proud supporter of recognition of Aboriginal and Torres Strait Islander peoples in the Constitution and of the voice. We give great hope to this moment in time. And I just also want to acknowledge that we're having this conversation in the construct of Western settler colonial laws, but I acknowledge also that there are two laws operating in this country. So thank you for that introduction, Michelle, and my respects to any First Nations peoples on the call today and to the countries where you're calling in from. So today, my name is Nicole Sommers. I'm a director at the Environmental Defenders Office, and I lead the Healthy Environment and Justice program. And our program is really underpinned by human rights and the environment. I'm just here to introduce you to the EDO and to give you an overview of what the work that we've been doing in this space. And then I'll pass over to my colleagues, Frances Bradshaw, who's an acting managing lawyer in the ACT practice, and Isobel Brinin, who's the senior solicitor with us. We're going to talk through what our work is in this space, and then talk you through our thinking about environmental human rights and why we should care about environmental human rights, and talk you through this idea of a human right to a healthy environment and how it could be recognised in Australia. So hopefully I'll leave you enough room for questions at the end. Please do engage. We'd love to have them. So to introduce you first to the EDO, the Environmental Defenders Office is probably known to some of you. We're a specialist community legal centre working with communities across Australia and with partners in the Pacific on public interest environmental law. We run strategic litigation, we provide legal advice and engage in law reform and legal education with communities across Australia. The program that I lead, the Healthy Environment and Justice program, was founded in 2020, and it was really founded on the principles of environmental justice and human rights and the environment. And we work with communities across Australia on environmental justice issues. I'll just give a brief overview. So I wanted to paint a picture for you so that you get some context about what we're going to talk about today in terms of the work that we've done. In 2020, my team started exploring the state of human rights and the environment in Australia. We knew that there were problems across the country. We deal with those problems every day. We talk with people, with communities every day. But we wanted to conduct a health check on our laws. Is our human right to a healthy environment protected in Australian law? What is the human right, and what would it look like in an Australian context to implement it? So we looked at our laws across the country, we looked at the implementation of the human right internationally, and we worked through the problems that we saw in the systems with case studies with our clients that we work with every day. What we found was not a surprise to us, but we found a segmented and siloing of the environment in Australian law and really a patchy protection of human rights. We found that our laws have failed to prevent or to respond to the triple planetary crisis that we face, the climate, ecological and toxics crisis. And yet we found also that we rely on the environment for our health and well-being. And in this State of Environment report that was released in 2020, we found that wellbeing was at the front and centre of the environment, and there was a definition of wellbeing that really was inclusive of our access to and participation in the environment as part of our psychological and social wellbeing. And so this demonstrated to us the need to recognise the human right to a healthy environment as a standalone right in Australian law. So what is the right to a healthy environment? Well, we'll take you through that in some detail in this conversation, but it's long been recognised in international law that the achievement of all human rights depend on a safe, clean and healthy environment. Indeed, the human right to a healthy environment isn't new. It was recognised in the Stockholm Declaration 50 years ago, which some of you may know about, which led to the principles of ecologically sustainable development, which are implemented in our laws. But it's also been recognised as a standalone right in the laws of over 150 countries. In other countries, it's implemented either through their constitution or regional agreements. The recognition of that right has, in the research that we've done, seen changes to both law and policy that have benefited peoples and the environment. Last year, in quite a momentous resolution, on the 28th of July, the human right to a healthy environment was recognised unanimously by the United Nations General Assembly, with 161 countries unanimously voting in favour of recognising that human right, and only 8 abstentions. And we congratulate the Australian government for being one of those countries that voted in favour of recognising this human right. So it is not a new human right. It is not something that is unknown. It is a human right that is now recognised at the international level as something that we all share and that a right that we have. But fundamentally, I just want to recognise that it's only in Western settler colonial law, and the concept of that intrinsic link between people and natures is really grounded in Indigenous laws and cultures across the world, and in First Nations law in this country. We have on the screen here the definition that's in the UNGA resolution, and a link to our report, which Francis and Isobel will take us through. Next slide, please. We've seen some movement to the recognition of environmental human rights, including in Australia, where we have human rights frameworks. In Australia, we have a Human Rights Act in 3 states, Queensland, Victoria and the ACT, and none at the federal level. But here I want to highlight a decision of the Queensland Land Court that we worked on last year, or the year before last, Waratah Coal and Youth Verdict. This was a case we ran for our clients, Youth Verdict and Bimblebox Alliance, and pictured here are Youth Verdict's representatives, which is a youth organisation concerned about climate change, objecting to a new coal mine in Queensland. We led evidence that the coal burned from this mine will impact the human rights of First Nations peoples in Australia by contributing to dangerous climate change. And this was the first time that objections to a mine in Australia were made on the basis that the approval would unjustifiably limit the human rights of Queenslanders protected under the Human Rights Act that was enacted in 2019. We took the court in another first to the Torres Strait and to Gimoy, Cairns, and heard evidence from First Nations witnesses on country under cultural protocols to enable First Nations witnesses to give evidence in a culturally safe way. This all led to, for the first time, the President of the Queensland Land Court deciding that she would recommend that the mine be refused, finding, amongst other things, that the mine would unjustifiably limit the human right to life, to cultural rights of First Nations peoples, the rights of children, the rights to property, privacy and home, and the rights to enjoy human rights equally. A momentous decision in Australia, and building on decisions that we see across the world, and the first time a coal mine has been refused on the basis of limits to human rights in Australia. Next slide, please. So globally, there is a movement for change and to recognise this human right. We see unanimous recognition by the UNGA. This is really an idea whose time has come, quoting from the Special Rapporteur on Human Rights and the Environment. We found in our report that it is time to legislate it in Australia. We've seen the right included in the Australian Human Rights committee's position paper on a human rights framework for Australia, which is positive, and we want to now explain to you what this all means and how it could be implemented in Australia. And with that, I'll hand over to Frances. Thank you.
Thank you, Nicole. I hope I've unmuted myself. Thank you. So I'll be going into this concept of environmental human rights. So most of you in this presentation will probably be familiar with human rights as a concept. Human rights are rights that recognise the inherent value of each person, independent of where we live, what we look like, what we think, or what we believe. They're based on principles of dignity, equality, and mutual respect. They're about being treated fairly, treating others fairly, and being able to make genuine choices about our lives. The source of human rights internationally comes from a number of international human rights documents and treaties. You've probably heard of the Universal Declaration of Human Rights, which sets out the basic rights and freedoms of all people. The Australian government has agreed to uphold and respect many international human rights treaties, including the International Covenant of Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights. Australia has also ratified the United Nations Declaration on the Rights of Indigenous Peoples, or UNDRIP. Before I go into an explanation of the development of the concept of environmental human rights, I wanted to touch base on the fact that as a result of signing and ratifying human rights treaties overseas, the Australian government actually already has international obligations that relate to our enjoyment of a clean, healthy and sustainable environment. So in 2018, the UN Special Rapporteur on Human Rights and the Environment identified 16 framework principles on human rights and the environment. These are 16 basic obligations of governments under international human rights law as they relate to our enjoyment of a healthy environment. They don't establish new legal obligations. They're derived from obligations governments already have as a result of international human rights law. They have just been moulded into being applied to environmental issues. So, for example, one of the 16 framework principles is an obligation that governments have to take additional measures to protect the rights of people who are the most vulnerable from environmental harm, taking into account their needs, risks, and capacities. This particular obligation is drawn from many international human rights sources, including, for example, the right to culture, which is recognised in Article 27 of the ICCPR. So what this means is that all governments that have signed or ratified human rights instruments, which includes Australia, already have obligations under international human rights law to ensure that we have a healthy and sustainable environment. Internationally, there has been a development in law called the greening of human rights. This development has been come about as a result of people overseas bringing cases and complaints before international and regional courts and tribunals, UN treaty bodies, and UN special rapporteurs, where these people have relied on their general human rights, such as their right to life, right to health, right to water, right to food, to protect aspects of the environment. So general human rights have been applied to environmental issues. One of the seminal cases in this movement, which you might have heard of, was a case brought by the Agenda Foundation against the state of Netherlands. So Agenda actually sued the Netherlands government to require it to do more to prevent global greenhouse gas emissions resulting in climate change. And the court actually ordered the court actually ordered the Netherlands government to further limit its greenhouse gas emissions. And it found that the government's existing pledge to do so was insufficient to meet its fair contribution towards reducing greenhouse gas emissions. The court concluded that the Netherlands has a duty to take climate change mitigation measures due to the severity and consequences of climate change and the great risk of climate change occurring. The decision was appealed twice by the Netherlands government, but both times were unsuccessful, and agenda was successful. One of the key findings of the courts in these decisions was that the Netherlands government failure to reduce greenhouse gas emissions was actually in contravention of its duty of care to protect human rights that are recognised under the European Convention on Human Rights, including the right to life and the right to family life, family home, and correspondence. Milieu de Fonzie is a similar case, relying on similar human rights, and was successful by the plaintiffs, although we note that Shell has actually appealed the decision, and that is yet to be decided. Another example, of course, of this development in Australia is the youth verdict case that Nicole mentioned in her introduction. Before moving on, I did want to briefly acknowledge that there are other sources of environmental rights in addition to human rights law. Environmental law is a source of environmental rights. We have rights, and government bodies have duties under environmental law that we, as the community, should be able to enforce. There is also a body of law called the Rights of Nature, or recognising legal personhood of nature in its own right, which Michelle is rather an expert on, and I'm sure many of you in this room have heard of before. And finally, another source of human rights are our collective and individual rights to the environment, which includes the standalone right to a healthy environment, which we will be discussing in a lot of detail in this presentation. So passing on now to Isobel, who is going to explain why we should care about human rights.
Thank you, Frances. Before I start, I'd just like to acknowledge I'm presenting today on the unceded land of the Ngunnawal and Ngambri people. So why do we care about human rights? Well, the science is clear that we are putting extreme pressure on our planet. Climate change, biodiversity, and pollution are all symptoms of the current triple planetary crises, and together they have been described by the UN High Commissioner for Human Rights as the greatest challenge to human rights in our era. Individually, each of the three are human rights issues that are deserving of equal attention. The human rights crisis is unfolding in Australia. The effects of the triple planetary crises are already being experienced by Australians, with these effects representing clear threats to the enjoyment of our rights. Some recent key examples of these effects include the 2019 and 2020 Black Summer bushfires, in which lives, property, billions of animals, and vast tracts of native forests were destroyed. The fires also significantly contributed to air pollution, with the health effects particularly acute for medically vulnerable people, such as pregnant women, children, and people living with chronic respiratory conditions. Rising sea levels and increased storm damage. As noted in the UN complaint case Daniel Billy, low-lying communities in the Torres Strait are already suffering from the effects of sea level rise, threatening the enjoyment of their rights to enjoy culture and to be free from arbitrary interferences with their private life, family, and home. Finally, dangerous heat waves. In many communities across Australia, both in urban areas such as Western Sydney, but also in remote communities, particularly in Central Australia, heat waves are now a significant threat to the enjoyment of human rights, not just in relation to life and health, but also standards of living, home life and privacy, and culture. It's worth noting that heat waves have killed more Australians than all other natural disasters, including bushfires, cyclones, earthquakes, floods, and storms combined. This is also an environmental justice issue, as the most vulnerable, due to overlapping socioeconomic and physiological risk factors, may also live in substandard housing poorly adapted to extreme heat. Finally, heat waves can affect biodiversity. So the recent fish die-offs on the Darling-Barker River are an example. This loss of fish and damage to the Darling-Barker River's health has a particularly acute effect on local First Nations communities, who have a deep cultural and spiritual connection to the river. We note also that the Bureau of Meteorology formally declared last week an El Nino with weather event, which will mean another hot and dry summer in Australia this year. These examples demonstrate that these impacts represent breaches of the human rights to life, health, and adequate standard of living, culture, and home life and privacy. As well as these rights, these impacts are breaches of many of the substantive elements which we'll address later, from which a healthy environment is derived. Consistent with global trends, Australia has seen an increasing crackdown on climate protesters, with anti-protester legislation now being implemented by multiple states and territories across Australia. The most prominent developments include amendments to the New South Wales Roads Act 1993 and Crimes Act 1900, and in South Australia, amendments to the Summary Offences Act 1953. EDO recently represented Knitting Nanas, Dominique Jacobs and Helen Cavelda in a constitutional challenge to aspects of the New South Wales protest laws because they impermissibly burden the implied freedom of political communication of the New South Wales community. Judgment is currently reserved before the Supreme Court of New South Wales. EDO has also witnessed an increase in proactive policing of climate activists across all Australian states and territories, including police raids, seizure of devices, preemptive checks, and onerous bail conditions, which are increasingly utilised as mechanisms for disrupting and isolating the environmental movement. EDO is deeply alarmed by this repression and the implications of human rights for climate advocates. This must be ameliorated by enacting a federal charter and state and territory human rights legislation that includes the right to a healthy environment, rather than relying on implied freedom of political expression. I'll hand back to you now, Frances.
Thank you. And before continuing, I'd like to apologise and acknowledge that I'm presenting today from the lands of the Gunai people in regional Victoria, and I apologise that I didn't acknowledge that before speaking earlier. In this section, I'm going to go into what the human right to a healthy environment is and its definition. So earlier in this presentation, Nicole mentioned that EDO has published a report on the right to a healthy environment in Australia. This report it explains what the right is, the extent to which it's recognised in Australian law, the benefits of including the right in law, and also makes a number of recommendations for why we should recognise this right in Australian law. And we'll be going through each of those points today. But if you are interested in reading more, you can find a copy of our report on our website, and there are links to it in this presentation as well. Several of you may have already attended a presentation a couple of weeks ago by His Honour Chief Justice Preston of the New South Wales Supreme Court, which His Honour delivered as part of this Earth Laws Month, as we are. And his presentation provided an excellent summary of the development of the right to a healthy environment and its interpretation. I won't go into this history in the same level of detail as His Honour. You can access a copy of his presentation on AILA's website and YouTube, but I will go into some key points as a sort of summary. So I wanted to acknowledge, as Nicole did as well, that the foundations of the right to a healthy environment really come from a number of ancient sources, including religious sources and Indigenous cultural heritage and traditions, which recognise humanity and nature as part of a whole. And also wanted to reiterate that while the right to a healthy environment, as we're talking about today, might appear as a sort of developing new legal concept, it's actually an idea that has existed since time immemorial. The Special Rapporteur on Human Rights and the Environment has defined the right to a healthy environment as being comprised of 6 substantive elements, which are 6 substantive rights. So a right to clean air, we have a right to a safe climate, we have a right to access safe drinking water and sanitation. We have a right to healthy biodiversity and ecosystems. we have a right to toxic-free environments, and we have a right to access healthy and sustainably produced food. These are all aspects of what the right to a healthy environment means and what it encompasses. But this list isn't exhaustive. It's going to evolve as our understanding of human rights law evolves internationally and in Australia. So, for example, in Australia, the right of First Nations peoples to carry out cultural obligations, to look after country and be with country, it's not captured in this list. But this right is critical to keeping our country not only healthy but happy. And so it's intrinsic to the notion of a healthy environment. The Special Rapporteur also recognises that the substantive elements of the right to a healthy environment need to be accompanied by corresponding procedural elements. Without these procedural elements, it's not possible to achieve recognition of the substantive elements. So these are the right to access information about environmental matters, the right to participate in environmental decision-making, and the right to access justice or access effective remedies in the courts for environmental harm or breaches of environmental law. The right to a healthy environment has developed internationally through two main movements. The first is that it has been recognised as a standalone right, which I just defined on the previous slide, and that is the right that we as EDO are advocating for recognition of in Australia. But before recognition as a standalone right, it was also recognised internationally as a precondition to the enjoyment of other human rights. So human rights authorities recognise that having a healthy environment is actually necessary for us to be able to fully enjoy our other human rights, like the right to life or the right to health. So what this means is governments have an obligation to guarantee a healthy environment in order to actually fulfil their obligations to protect and fulfil other human rights. And this is whether or not the country has separately recognised the right to a healthy environment as a standalone right. On this slide, we've set out a brief timeline of the development of the right to a healthy environment as a standalone right. Won't go into everything on this slide, but essentially, as Nicole mentioned, the right to a healthy environment, as we understand it, it's not a new right. It's been recognised since at least the 1970s in the Stockholm Declaration. More recently, in July last year, the right was recognised by the UN General Assembly as a universal human right. And today, more than 80% of UN member states, which is approximately 160 out of 193 countries, recognises the right to a healthy environment in their laws in some form. On the slides, we have links to where you can access maps and information about the countries that recognise the right to a healthy environment in their laws. Notable absences are China, Japan, the United States, and, as we will discuss in this presentation, Australia. So, yes, the right to a healthy environment is not expressly recognised in any federal or state or territory human rights law in Australia. The ACT government announced at the end of last year that it's going to introduce the right to a healthy environment in the ACT Human Rights Act. But we are yet to see a bill. We understand it's going to be produced sometime this year. Regardless, at EDO, we argue that the right to a healthy environment could be recognised as a precondition to other human rights that are protected in the ACT and other places that have human rights legislation. So, for example, the right to life or the right to culture. But at the moment, there is no express human right to a healthy environment. We did want to note that the Victorian Environmental Protection Act does have a form of the right to a healthy environment under, it's described as the principle of equity. It is an environmental principle that the Victorian EPA needs to consider when it makes certain decisions under that legislation. which is fantastic, a great start. However, it is very limited. It offers limited protection of that right. It means that the Victorian EPA will be considering the extent to which that right is protected when making decisions that concern the Environmental Protection Act. It's not a broadly applicable human right that applies to everyone in Victoria or in matters that don't fall under the remit of the Environment Protection Act. And for this reason, we continue to advocate for the recognition of a standalone right to a healthy environment in Victoria and all other states and territories in Australia. And I will pass to Isobel now to talk about Australia's human rights framework, which I've just touched on.
Thanks, Frances. So although Australia has signed 7 of the 9 main international human rights treaties that commit Australia to protecting and promoting human rights, the majority of our international commitments have not been translated into Australia's national laws. As Frances mentioned before, Australia is the only liberal democracy in the world that doesn't have a bill or charter of human rights. Australia has some federal legislation that addresses discrimination, and there are some protections of rights in common law and also in the Constitution. However, many human rights, such as the right to free speech or freedom from torture, have limited protection in Australian law. The ACT, Victoria and Queensland each have their own human rights legislation. Under those human rights laws, state or territory government agencies and their employees have a duty to act consistently with human rights and to properly consider relevant human rights when making decisions. There are different options for people to enforce their human rights in each jurisdiction, each with their own limitations and barriers to access. In addition, new bills and legislative instruments that are introduced into their parliaments are assessed for their compatibility against local human rights legislation. However, as Frances touched on before, none of the state or territory human rights acts expressly contemplate the environment, and while those acts are very welcome, there are limitations in the laws, the human rights they recognise, and the remedies available for the breaches of those rights. The remaining 5 Australian states and territory do not currently have human rights legislation. In March this year, the Australian Human Rights Commission launched a position paper outlining its proposal for a Human Rights Act for Australia. This is important because it would create legal protections for the human rights of all Australians and provide ways to seek justice for breaches of those rights. It would also provide options for people to challenge decisions that breach their human rights and opportunities to go to court if their issues can't be resolved through conciliation. This model would also increase the responsibility that governments have to consider how their laws, policies, and actions might affect people's human rights. The Commission has proposed that the right to a healthy environment be included as a recognised right in the proposed Act. EDO agrees with this proposal. Also in March this year, the Attorney General referred an inquiry to the Australian Human Rights Framework to the Parliamentary Joint Committee on Human Rights. As part of the inquiry, the committee is considering whether the Australian Parliament should legislate a Federal Human Rights Act, and if so, what it should include. EDO made a submission to the inquiry, making 14 recommendations, including that the Australian government should enact a federal charter of human rights and freedoms. EDO also recommended that the charter should include the right to a healthy environment. EDO says that the right to a healthy environment should be defined broadly, consistent with international law. The submission with all 14 of our recommendations are available on our website. This inquiry is ongoing, with a number of public hearings being held in September and October, and EDO is due to give evidence in the inquiry this Thursday. Thanks, Frances.
Thanks, Isobel. I can see we don't have too much time left before we jump into questions and answers. So as I go through this section, I will try to keep it succinct. In our report on the right to a healthy environment, we have identified 4 main arguments for why we consider the right to a healthy environment should be recognised as a standalone human right in Australian law at both the federal and state and territory levels. Really, as Nicole went through in her introduction, the research we undertook as part of our report identifies that our current environmental laws are not doing enough to adequately protect us from and our environment. There is a siloing of environmental issues. There is no there is piecemeal protection of aspects of the environment, but no concise, broadly applicable protection of the environment. And as Isobel went through, we can see the effects of that in the fact that Australians still continue to exist impacts from the triple planetary crises of climate change, biodiversity loss, and toxic pollution. Secondly, as Isobel also went through just now, we do have some human rights law at a state and territory level in Australia, but we do not have federal human rights law. And at the moment, this offers only piecemeal protection of the environment. Our human rights legislation protects certain political and civil rights, but not all of the rights that are protected under the treaties that Australia has ratified. And they don't actually include any or contemplate the environment. So again, there is limited protection of a healthy environment under those laws. And Australians are experiencing unacceptable levels of harm to our natural environment and to our health and our well-being. And finally, those impacts are felt disproportionately by First Nations peoples and other overburdened people who are at the most risk of environmental harm, but also often the least responsible for that harm. They're disproportionately impacted, and so is their health and their well-being. We have examples of case studies in our report, and I encourage you to read them if you're interested in finding out more. In contrast, there are several benefits to recognising the right to a healthy environment as a standalone right. As a human right, it will have broad application. It will offer comprehensive protection of the environment than is currently offered by our piecemeal ad hoc protection of the environment under our current environmental and human rights laws. As a human right, it puts people and communities at the heart of environmental protection, gives us more rights to actually fight for the environment in which we work and live and play. It's also important to note that including the right to a healthy environment is actually consistent with our existing legal frameworks in Australia. Australian parliaments have already taken steps to legislate protection of the environment by having acts on environmental protection, among others. And some of those laws actually already recognise that there is a clear link between environmental degradation and the impacts this has on our health. And similarly, the three procedural elements that I spoke to, such as the right to access information, that right is already included in a number of environmental laws in Australia. So including the right to a healthy environment would actually just build on an existing legal framework. And it's a necessary and logical extension of the laws that we already have. Finally, it will not open the floodgates for vexatious litigation. Previous governments have described the use of litigation to challenge environmental decision-making as environmental lawfare, but there has been a legal analysis done of challenges under the EPBC Act that found only a negligible number of cases could actually be described as, that no cases that could be identified as actually being vexatious. Only a negligible number of decisions are actually challenged in practice. And a high percentage of the cases that were brought on public interest grounds were actually successful. So what this means is that there were genuine legal issues for the courts to consider, and therefore those decisions are contributing to positive developments in our legal jurisprudence. Decisions like this play an important role in upholding the rule of law. It increases government accountability and improved government decision-making, which can only be seen as benefits. Thanks, Isobel.
So in our report, we identified 4 key benefits to recognising the right to a healthy environment. The first one is it will lead to improved human and ecosystem health outcomes. So studies from countries that already recognise the right to a healthy environment show that recognition of the right has contributed to environmental benefits, including cleaner air, enhanced access to safe drinking water, and reduced greenhouse gas emissions. It is also likely that the right will have a positive impact on Australia's economy, including by reducing the impacts on Australia's healthcare system. Secondly, stronger environmental laws and governance. So again, countries that recognise the right to a healthy environment have witnessed a number of positive developments in law reform and in better enforcement of environmental laws, regulations and policies. Using a human rights lens to frame environmental protection will also shape law and policymakers' understanding of the environment and its relationship with and to humanity. In addition, introducing the right to a healthy environment would mean that scrutiny committees, parliamentary drafters, and public entities will need to consider the protection of the environment and human health when making new laws. Thirdly, improved access to justice for environmental harms. So a 2018 study found that countries that have procedural environmental rights entrenched in their constitutions have experienced positive environmental justice outcomes. Also, as mentioned previously, there are currently only limited remedies available through Australian human rights law. Finally, it reduces environmental injustices. So as benefits of the right to a healthy environment include stronger environment protection and healthier people and ecosystems, it then follows that we could expect to experience less environmental degradation in Australia. This would reduce the presence and impact of environmental injustices on overburdened communities and improve the distribution of environmental benefits in Australia. Next slide, please. The UN Special Rapporteur on Toxics and Human Rights recently completed an official visit to Australia to examine the impacts of toxic pollution and hazardous waste on human rights. At the end of this visit, the Special Rapporteur identified that recognising the right to a healthy environment is the most immediate and momentous opportunity for Australia to tackle this issue. Thanks, Frances.
Thank you. I will just say, because we want to leave some time for questions, that we detail the 4 recommendations that EDO makes in our report, which is accessible online. Really just want to drive home that our main recommendation is that the right to a healthy environment should be included as a standalone human right in federal and state and territory human rights legislation, whether that legislation currently exists or it's going to be created in the future. And that if the right can't be included in a federal act of human rights, then some other kind of federal legislation that would allow the right to be broadly applicable to environmental and human rights issues. But really, our recommendation is that we need a federal act or charter of human rights. It needs to include the right to a healthy environment. And I will wrap up there. Thank you very much.
Fantastic. Thank you so much. The time is now, if not 20 years ago, exactly. Thank you, lovely ladies. We might stop sharing screen. We've got about 10 minutes for some questions, unless we can entice the EDO ladies to stay a little bit longer. We have a range of really excellent questions, and I'm trying to group them together so that we can be succinct. But I'll start with 2 questions that relate specifically to the human rights aspects that you've been talking about. There are several others that are talking more generally about legal issues. So thank you again. And obviously any of you can answer these questions. Victoria has asked, can you please expand on how the right to a healthy environment will protect the right of peaceful protest, especially in the context of the increasing criminalisation of protest activity across Australia? Any thoughts on that one?
Yeah, thanks. I've been watching these excellent questions in the chat, Michelle, so I'll give that one a go. I think the easy answer to that is the human right to a healthy environment, as we see it, is implementing as a starting point the framework principles that have been developed by the United Nations Special Rapporteur on Human Rights in the Environment. So he was tasked with looking at what the human right to a healthy environment should be made up of, and he came up with 16 principles. One of those principles relates to the protection of environmental defenders, so the right to freedom of expression for people wanting to undertake environmental protest. So it's expressly recognised in the framework principles, so we would say it as incorporated within that human right. How does that in fact protect it in Australia? Depends on the human rights framework that you're looking at, but it is incorporated in the human right to a healthy environment, which is why we say it's important.
Thank you. And there are two questions that relate to the reliance on the law focusing on human rights when we know that the impacts of pollution and environmental destruction affect all life and all creatures. For example, one comment is, I'm a strong supporter of the right to a healthy environment, but I'm also very passionate about the rights of nature to be independent of its use to humans. Do you see any potential issues with the framing of environmental protection through a human rights lens as opposed to protecting the non-human world for its own sake? Did you want to talk a little bit about the constraints in the current Australian legal system, about why we quite literally have to it's hard enough getting a right to the environment for humans, let alone nature rights, which we can all talk about in a separate session, because rights of nature is a huge topic. But please, your thoughts.
Yeah, so such a great question. And I think that if you're coming really from an environmental lens, which, you know, I've come from as well, you grapple with this question when you're looking at human rights frameworks. But ultimately, you know, one of the things that we see is that the environment doesn't have power in the courts, and it doesn't have its own rights in the Australian legal context. You know, the EDOs were really developed out of this question of, do trees have legal standing? And that's really was one of the founding elements of having someone who can take action on behalf of nature. But in an Australian legal context, to have standing to do that, you need to be directly affected by, you know, the decision that's made, or you have to show some link in order to take legal action. So in our legal system, humans are placed at the centre of the legal system, and bringing human rights actions actually enables you to do that in a different way. But I think the human right to a healthy environment challenges us also to think about things differently, about challenges us to think about not so much this is about protecting humans for humans' sake, but about thinking about humans and nature as intrinsically linked. So I started off talking about that concept of us being one, and about harms to the environment as being harms to self, really is part of that equation. So I think the framework principles that we have at the moment don't go into kind of biodiversity or, you know, nature and harms to nature as being harms to humans in the way that we might see it develop. But if we go back and think about, there was a great question in there about First Nations culture and thinking about First Nations culture and harm to the environment. Harm to the environment is harm to self. So I think we can think about human rights in the environment as a way of bridging the gap between humans and nature, which has been carved out by colonisation and by our Western settler colonial laws.
I agree with everything Nicole said. I also wanted to add that the concept of the right to nature, so rights of nature, and the human right to a healthy environment, those concepts are intrinsically linked. As Nicole explained, at its core, the right to a healthy environment recognises that there's an intrinsic link between human health and the health of our environment. So environmental harm interferes with the enjoyment of all human rights, and the exercise of human rights opposite helps to actually protect the environment. And overseas, there are examples of the right to a healthy environment being included or formulated in at the same time as rights of nature. Chile, the Chilean Constitution being an example of that. So they're not mutually exclusive; they are intrinsically linked. Thank you for that question. It's very on point.
Yeah, and I'd love to have you, all of you, back one day for a broader discussion about the long-term vision for where environmental law could go. But in the meantime, can I give a plug? This Thursday, I feel like I'm doing an online marathon from 9 a.m. till 8 p.m, where we're going to have updates about rights of nature from all around the world. I basically reached out to a bunch of friends. They all said yes. So we have updates from Ecuador, some other aspects of South America, the Philippines, India, the US, Ireland, Spain, and many other places in between. So I've put the link in the chat there, folks. It's on the Earth Laws Month calendar and the Humanitics. So the rights of nature is a really interesting area. There's a lot of complex issues when you're looking at a colonial country like Australia, because Aboriginal people didn't technically have a rights-based approach to law. They had a law of obligation. So even thinking about rights of nature in Australia, it has to be done in a way that's not continuing or perpetuating colonial law. So it's a tricky space. It's really, really interesting and very important. A couple more questions, if I can squeeze a few more in, lovely ladies. So Karen has asked, thank you for your patience, Karen. She was the first one in with a question. Can we bring more class action human rights cases against state and federal governments for approving new coal mines because they are not reducing greenhouse gas emissions sufficiently? How might we do that? I mean, that's not really a short answer kind of question, is it? But any thoughts quickly?
Not a short answer question, but a great one and one we get asked a lot. I think that, my answer to it is it depends on our legal framework. So what state you're in, in Queensland there is a Human Rights Act. So the youth verdict case was the first case, as I've said, where a coal mine was refused because of the incompatibility of the coal mine and the emissions of the coal being burnt overseas on Queensland and on the rights of First Nations peoples in particular. So that is a great example of where we're headed in this country, and it really picks up on international movement that Frances has talked us through.
Excellent. I'm just looking at the time and a quick question. Let me think. Well, we have a couple of other questions about taking actions and things. But perhaps Joy has asked, I'd like to hear your thoughts on the Climate Change Act amendment, please. What do you think the Act is trying to achieve? And is the amendment only adding children's health and well-being?
Michelle, I think this is talking about the David Pocock bill. I'm not particularly across it, but obviously it builds on the case of SOMMER that was taken by a group of young people in a federal court, and that was looking at an implied duty of children that was overturned by the full federal court. Obviously at a federal level, one of the things that we see that's missing is duties to protect all of us, including intergenerational inequity, through our existing system of laws. So that includes the EPBC Act, that includes the absence of a human rights framework. So that duty is something that we've recommended in looking at a national EPA, for instance, but what we have recommended in our report is that it goes into the, it's called the PGPA Act, the Public Governance and Public Administration Act, so that it sits across all decisions that are made and not just be confined to the environment. So yeah, it's a great move, but there are so many ways of doing that at a federal level.
And there's already been a number of comments on people worried about the vested interests of fossil fuels and regulatory capture in government, but yes, important. But look, just quickly, I think I can squeeze in 2 more questions. Karen has asked, are there clear, readily available guidelines state by state that we can get to know how to avoid getting policed or breaching the anti-protester legislation?
I feel like I'm hogging all the questions here, but Frances or Isobel, feel free to chime in on that. We have resources that are available on our website, so you can go through a search to look at the fact sheets that we have up there. And I know we have some fact sheets on protest laws. We've also got a report that we prepared with Greenpeace, I think it was 2 years ago, called the Global Warning Report, the Threat to Climate Defenders in Australia. So I might just post a link to that, because that might be a great starting point.
And I've put the EDO link in a few times, so hopefully people can find it. And then a final question, I'm just sort of abbreviating Paul's very thoughtful question. What rights do we have to protect land, water and air on the basis of spiritual and sacred relationships, connections or oneness with our natural home? I work closely with traditional owners in this work. And and he's saying we need to move beyond this sort of reductionist materialist conceptions that are basically preventing us from caring for the place. Sorry, Paul, I had to shorten your question. Thoughts?
Paul, great question. I saw that earlier as well. And what I was going to say was, I'm going to go back to the youth verdict case. Really interesting discussion of the rights to culture in the Queensland Human Rights Act. The evidence that was given, it's really worth reading, and I might just post a link to that decision as well. There were people who lived on the Torres Strait Islands talking about their connection, their deep connection, thinking about the earth as a mother, and that they have to leave their mother and will be displaced by climate change from their mother. It's moving, difficult evidence, but that idea of cultural and spiritual connection is something that the court recognised, and the displacement being, you know, over another level, and one of the core reasons that the court determined that the coal mine should be refused. So that idea of connection, we might see built in the law under the Human Rights Act in Queensland, but and perhaps in other jurisdictions as well.
Thank you very much. Look, it's 2:05. We've covered most of the questions. I apologise if I haven't been able to get to all of them. There's lots of lovely thank yous. And one person said, love your work. How can I support you? Certainly, I would suggest you go to the EDO website. There's always a button for donations, to become monthly donors, to become supporters. So if you're able to, please do. The work of the EDO is critically important. The only, well, one of, but mostly the largest public interest environmental law firm in Australia. So please do think about connecting with the EDO and supporting them. And please do think about checking out the things that Ayla gets up to, including this Thursday's various webinar discussions about rights of nature. And also Thursday evening, we've got an update on the push to make ecocide a law in international law with Jojo Mehta from Stop Ecocide International. And yeah, the link for Judge Preston's fabulous talk a few weeks ago, which actually kicked off Earth Laws Month, is in the chat. So Nicole, Francis, Isabel, thank you so much for your time and the extensive knowledge you have shared with us. Very important. And we look forward to dragging you back into the online world and away from your court case for a little moment in time, perhaps next year, and get some more updates. Thank you all of you for joining us, and really appreciate your thoughtful questions. I hope you all have a very lovely day.
Thank you very much, Michelle, for hosting us. It's been a great audience as well. Thank you so much.
Thank you, everyone. We'll see you soon.
Thanks, everyone. Bye.